Hi, everyone. Hello. Hope you're good. Hope you're fine. You're welcome to Lawyers Info Hub. Um, it's a pleasure to always create content on this platform. This is a platform where we reach out to law students, lawyers. We share legal tips to help you become better in whatever you're doing as a lawyer, as a law student, to excited when you excel, and we want to help smart lawyers in their practice. So today we're looking at raising fresh issues on appeal. Now, you remember that when your matter moves to the appellate court, be it the Court of Appeal or the Supreme Court, what the court at that point is looking at is what the lower court didn't do right. Now, so this is not a place you give evidence. The appellate court is not a place you give evidence like the trial court where they'll hear both parties, you put in your documents and all of that. So, but what the Court of Appeal or the Supreme Court or the appellate court are using the both courts as appellate court. So, what those the appellate court will look at is what did the lower court not get right? They didn't misapply the law. Well, did they erroneously miss the point? No, did they erroneously apply the law? Was there a misdirection, an error in law? These are what the Court of Appeal will look at based on the record before them. I know that the record of appeal is just a compilation of all the processes filed at the lower court. That is what we call the record. So that is what the Court of Appeal or the Supreme Court will be looking at in analyzing or making their own decision. Did the lower court, the trial judge, analyze the issues well? Did it juxtapose it with the law and facts? So this is what the appellate court, does when cases or matters are brought to them. Now, how can you raise fresh issue on appeal? Yes, it's possible to raise fresh issues on appeal, but there are things you need to do and there are things you must know. Now, it's important to note that before a party is permitted to adduce evidence on appeal, it is necessary that the issue in respect of which this new evidence or the further evidence is being tendered must have been pleaded. What this is trying to say is that if someone is trying to raise a fresh issue on appeal, it should not just be fresh in total like it has never been heard. The issues must have been, part of what was discussed at the trial court. Rather, you just bringing in new maybe documents to buttress that point. I'm just trying to explain it in a more literal way so you can understand. You know. Now, the issues sought to be, established by further evidence must be one pleaded before the trial court by the pleadings of the parties, to allow additional evidence on facts that were not pleaded at the lower court or the trial court. It negates the principle of law, to the effect that evidence led on facts not pleaded goes to no issue. Now, and if additional evidence are just being allowed to be, brought on appeal, then there won't be end to litigation. There will be back and forth. Now, if the Supreme Court has the power, to admit fresh evidence on appeal when an applicant's affidavit evidence have fulfilled certain conditions that justifies the exercise of the jurisdiction, the discretion of the court. Now, looking at instances where the Supreme Court can admit fresh evidence on appeal. Now, first of all, some of those conditions is that the fresh evidence sought to be adduced must be sought that could not with reasonable evidence or reasonable diligence be obtained for use at the trial court. Now, for example, I'm using as an example, you mentioned that maybe that plaintiff the plaintiff, maybe let's say, is the owner of the land, but there were no documents. You couldn't find those documents, or there were other documents you front loaded. I'm using this as an example in proof of those or assertions. But maybe the C of O was lost at that time, or you were able of looking for it and did your you've been there have been thorough investigation or search, and you still couldn't see it at court of the Supreme Court. Can, if you now find, I'm just using this as an example, if you now find that C of O, remember that at the lower court. You mentioned it, but it was not available. So uh, at the Supreme Court cannot admit it if he saw that there was reasonable diligence search, but it could not be obtained for use at the trial. Now, the fresh evidence must be sure that if it is admitted, would have an important effect. Is very crucial to the determination of the issue, and you have a very positive impact on the case. Now, the fresh evidence must be such that is apparently credible in the sense that it is capable of being believed. At that level, it is an evidence that's capable of being believed. It's not something that you bring up like, no, 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 it can't work. It is an evidence that's capable of being believed. It need not be necessarily, it need not necessarily be incontrovertible. So it must be such that an evidence that is believable. Very, very important. You need to understand that part. Evidence that's really, these are things you put up in your affidavit to, let the court know that, okay, during the trial stage, we couldn't, obtain it despite our diligent search, our diligent efforts to get it. Now, the additional evidence could not have influenced the judgment. No, that the additional evidence could have, yes, not could not, could have influenced the judgment of the trial court had it been made available and tendered at the trial court. Now, what is he trying to say? That in your affidavit, you put in that had this evidence been available at the trial court, judgment should have been in our favor. It would have, helped to swing the the scale of justice to your favor. So that's part of the things you aver, that evidence sought to be brought or adduced now at the appellate court could have influenced the judgment of the trial court. The fresh or additional evidence sought to be introduced must be material, it must be weighty, although not conclusive. So these are things you have to put up in your affidavit, to you know to so that the discretion of the court can be in your favor. Now, let's also look at other conditions in raising fresh issue on appeal. For an applicant to successfully raise fresh issue on appeal, the following conditions must be present. You have to look at the fresh issues must be substantial points of law. We discussed it earlier, and all the facts in support of such fresh issue can be, gathered or garnered on the record of appeal. What he's trying to say is that this evidence was partly mentioned or it is predictable at the lower court from what has been pleadings and all that, just like it was not available. So there are facts in support of that evidence on the record of appeal. The evidence must be so that if admitted would have an important or necessarily crucial effect on the whole matter. You know, it must be, just like Abele said, it must be believed, it must be crucial, it must be something that must be believed. Like when it's brought up, people like, okay, no more arguments on it. It must be so that apparently credible in the sense of it being capable of being believed. Now, these conditions must coexist before the applicant can exercise his discretion in granting you leave to call further evidence. So you can check out the case of UBN, that's the Union Bank of Nigeria PLC against Petro Union Oil and Gas. It's a 2022 7 Nigeria Weekly Law Report. It's part 1829. Part 1829. Yes, part 1829. Then is 199, page 199, page 199, 241 to 242. You can also check out the case of Kaza against the state, 7 Nigerian Weekly Law Report, the 2020 and 2008 7 Nigerian Weekly Law Report, part 1085, 125, at 125. You can check out also the case of Adeyefa against Bamboye, the 2013 10 Nigerian Weekly Law Report, part 1363. Very important on how the appellate court can admit fresh issues It's very, 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 very crucial for you to understand this point. It's the discretion of the court, but you must present, ava facts that will, make the court, give, extend this discretion to you. you know. So the appellate court have the discretion to allow parties adduce fresh evidence, but this condition you have listed, you must, put it down in your affidavit, supporting your motion, and then argue in the written address on the essence of that evidence. Why is it important that if it was there, that the judgment would have gone in your favor at the trial court, that um, it was not available despite reasonable diligent search of that evidence at the trial. I know that the facts in support of this fresh evidence must have been part of the record. It's not like something coming from the sky. It's part of the record, so that it was not available, as at the time of trial. Now, you remember that the leave of court is required before a party will be permitted. So it is that on the granting of that your application, motion on notice, seeking leave of the appellate court or the honorable court to adduce fresh evidence. So when that leave is now granted, that is when you can now adduce the fresh evidence. So the leave of the court is required before a court will be permitted to adduce fresh evidence on appeal. And you know that the discretion of the court will be exercised, judicially and judiciously, but there are conditions you must meet, as a matter of law, before the discretion of the court can be in your favor. So there are guiding principles, just like we have mentioned, uh, that the fact that the evidence sought to be adduced could not have been used uh, because it was not available despite all reasonable, search to obtain it. It's an evidence that would have, or let's say, tilted or swung the scale of justice to your favor and have changed the impact of the judgment or changed the judgment at the lower court. It should be something weighty. It should be something that is believed, though it need not be incontrovertible. It must be involve substantial points of law, and the facts are some things that can be, seen on the record. It's not like it's coming from the blues. So, friends, it's possible for fresh evidence to be adduced at the appellate court, but you must understand these conditions and you must put it so that before the in support of the applications, so that the court will look at it and say, okay, we can exercise our discretion in the party's favor, and the essence of that evidence is key. So as much as always tell you at the appellate court, no new evidence and all that. In special circumstances, further evidence, fresh can be adduced, and also fresh issues can be raised. So fresh issues can be raised, further evidence can be adduced. So don't confuse yourself. Further evidence can be adduced, fresh issues can be raised, but there are conditions to be met. So, friends, it's been a wonderful time. If you are yet to subscribe to this channel, please do hit the subscribe button. We just share legal tips in the most simplest way. Something that can help you, you can retain easily, and you can even share to other people around you. So it's been a nice time talking with you, speaking to you, sharing legal tips with you. We just want to contribute to the growth of the legal profession, so that you can always find a place you can always run back to look out for legal concepts in the most simplest or way you can understand them. So it's been a nice time. Do know that you can always be the best. Don't be weary. Keep improving yourself. Keep adding value to yourself. You can always be the best. You know, uh, the sky can be your starting point. Do take care of yourself.